is out. We'll now go to SB 1186.
Thank you, Madam Chair. Appreciate it, members. SB 1186 is substantially similar to a bill this committee approved last year, which was SB 21. It ensures that state law keeps up with law enforcement's rapid adoption of surveillance technologies. If the police want to search your phone, your car, or your house, they have to get a warrant. But many agencies have technology that can track where you go, who you talk to, and what you say in public places without any safeguards. Over 100 law enforcement agencies in the state are thought to use some type of surveillance technology, and many deploy multiple kinds, including facial recognition technology, software that can monitor social media websites. SB 1186 expands the transparency requirements established for license plate readers and cell phone tracking devices established in 2015 to all surveillance technologies used by law enforcement agencies. This means surveillance technology will be subject to public disclosure and local legislative review. Surveillance technologies must be governed by a surveillance use policy, and law enforcement agencies must produce biennial surveillance reports. The bill provides an exigent circumstance provision to law enforcement to allow them to use unapproved surveillance devices in emergency situations. Law enforcement groups will argue that creating transparency provides a surveillance roadmap to criminals. This is not the case. The mere knowledge of a police tactic does not render it useless. There are already laws mandating the disclosure of wiretaps and license plate readers, and both technologies still help catch criminals. Some concerns may also be expressed by the breadth of surveillance technologies covered by the bill. SB 1186 recognizes the wide and ever-changing array of surveillance technologies at the disposal of law enforcement now and in the future. The goal is to be specific enough to capture the appropriate surveillance devices, but not overly prescriptive so that we would have to run a bill each time a new technology is invented. In closing, I'd like to make one thing very clear. This bill does not prohibit law enforcement from using surveillance technology to fight crime. I support using technology to increase public safety, but we need to safeguard basic civil liberties from potential abuses. We live in a nation of laws, a nation founded on democratic accountability. And as Thomas Paine once said, quote, "A body of men holding themselves accountable to nobody ought not to be trusted by anybody." I respectfully ask your aye vote, members.
In support.
Larry Doyle on behalf of the Conference of California Bar Associations in support of Senate Bill 1186. Surveillance technologies are in many ways wonderful things. They help us to be safer. They're now more a part of daily life and daily culture than ever before. But just going back to 1984, the book we all read in high school at some point, I think, still. Surveillance technology carries with it, there's a certain fear. You have to be sure that it's being used for the correct purpose and not for external purposes here. So this bill represents a balance, an excellent attempt to try to balance our ability to be protected with our ability to be free. And Senator Hill's been working on this for a long time. I admire everything that he's done in this effort. I know we will continue to work with the opposition as the bill goes along, and we ask you for your aye vote.
Any other witnesses in support? At the mic.
Morning, Madam Chair and members. Kevin Baker for the American Civil Liberties Union of California. We think there's a good idea in theory in the bill. We do not yet have a position on it because we're concerned that the bill does not treat equally all of the law enforcement agencies that have this kind of surveillance technology, because it excludes DAs and sheriffs from the requirements of the bill. We're troubled by that precedent. We understand that law enforcement, the DAs and sheriffs, believe that there is a government code provision that is in conflict, that gives them the total right to use these surveillance devices without that kind of oversight. We think the legislative body of the counties ought to govern the acquisition of this surveillance technology just as it does in cities, and there's no good policy or legal reason to exclude them. I just also note that when the committee heard the bill last year as SB 21, it did not have that exclusion for the DAs and the sheriffs, so we would ask that that be put back into the bill. Thank you.
Appreciate your comments. That is a neutral position. We'll see if there's any other witnesses in support. All right, witnesses in opposition can come to the table.
Morning, Madam.
Two at the table.
Morning, Madam Chair and members. Corey Salzillo here on behalf of the California State Sheriff's Association. Respectfully, but regrettably in opposition to SB 1186. We did oppose SB 21 last year. To the prior conversation, the bill last year did include sheriffs and district attorneys, speaking on behalf of sheriffs now, in the bill in as much as it required sheriffs to seek approval from the Board of Supervisors to acquire surveillance technology. That requirement was removed from the bill during the process last year, and then the bill was reintroduced this year without that requirement. So again, the divergent treatment between elected officials and non-elected officials. And Mr. Baker referred to a government code section, and I believe it's 25303, that effectively says that the Board of Supervisors cannot regulate the investigative authority of the sheriff's office. And so that was the concern about that particular provision. But we acknowledge that that is out of the bill this year. Nevertheless, we remain opposed to the bill based on the point that the author made, that this bill does give a roadmap about surveillance to criminals who would use that information to potentially overcome the surveillance or to avoid the surveillance. The bill very clearly requires that the surveillance policy contemplated by the bill include information about what types of surveillance are used, what types of data can be gathered, and how those surveillance technologies are monitored for security. So not only what is being collected, but how we secure it to keep it from getting into the wrong hands. And we think that the risk involved in publicizing that sensitive information dwarfs the perceived benefit emanating from making this information public. We remain concerned about the requirement to hold a public hearing on this, again, because of the sensitivity of the information. We don't have a problem with transparency, but the reality is that this is requiring us to put forward a very clear delineation of what types of surveillance we use, how we use it, and how the data are protected. We think that's too much of a risk of that sensitive information. Thank you.
Thank you. Next witness.
Madam Chair and members, Jonathan Feldman with the California Police Chiefs Association. Will echo the comments of my colleague and add that the burden this bill establishes on setting the policy, amending the policy, getting it approved, shutting down use of all surveillance technology until the policy is approved or amended every time you require the collection of new information or add new technology into your existing repertoire, just make it practically impossible for a lot of agencies to comply with. I have chiefs in small agencies where they have 5, 6, 7 sworn officers, maybe 20. They don't have the time to develop this policy, rewrite it, change it, get it approved every time they need to collect new information or acquire new technology. There is an exigent circumstances provision in the bill, but it's also practically unworkable. It says you can't collect information unrelated to the exigent circumstance. So if you're going after a kidnapper and you find out information about a murder, you can't collect that information, you can't store that information. That information has to be deleted as soon as you're done with the exigent circumstance, which I don't know who's defining when the start and stop of an exigent circumstance is in this situation. It's unworkable. So I appreciate the intent of that amendment or that provision in the bill, but it does nothing for us. And also, locals can do this right now if they want. If a local Board of Supervisors or local city council wants to set surveillance policy for their law enforcement officers, use of certain technology, or for the department, they can go ahead and do that. We don't need to do this at the state. And a lot of this stuff should be debated at the local level with local law enforcement in discussions with their local council members. I mean, a lot of you came from local governments. You know that most policy is best handled at that level because you can really get into fine-tuning what works for that community, not setting something statewide. Now, we've come to the table on a lot of negotiations around the use of surveillance technology in the past. You know, we have negotiated on the Electronic Communication Privacy Act, on other bills with the senator related to this, the use of this kind of technology. But the burdens in here are just too high for us to do anything but oppose this. And last, I'll end with There's I was on a panel on artificial intelligence and the growth of technology and its use in law enforcement. And yeah, there's a lot of stuff that's being developed that probably gives a lot of folks some privacy concerns, but there's also tremendous potential for it to benefit public safety. We look at some of the mass events of violence that have been taking place across the country, to be able to spot those events early and predict them, get in front of them and stop them from happening. That's what this technology is going to allow us to do. So if you get too restrictive and shut us down from using it, you're going to see those benefits go away. And that's why we have a lot of concerns here and have to stay opposed.
Before I have the other witnesses, I'm going to call on Senator Jackson, but I would point out that this bill does not dictate what the policy of the local government would be. It just, it in effect requires what you described, which is the ability for the locality and the departments to work out what their surveillance policy is and to have a public hearing on that. So it does not dictate what the policy of the local government would be. Senator Jackson.
Thank you. Thank you, Senator Hill. This bill will go to the Judiciary Committee next, and I have a number of issues related to that, which I'll defer to that committee. There's a philosophical issue, though, that I think, if I may, inquire about here. So we have written right into our Constitution, the founding fathers of this nation understood that without necessary checks and balances, we could find ourselves in, as Mr. Doyle indicated, a 1984 situation. And as we see these technologies advancing and becoming very sophisticated, we also see a vacuum. We know that if you wanted to wiretap a telephone, you had to get a warrant. We have developed in this country a system to protect against the abuses by law enforcement. We want to, however, give law enforcement the tools that it needs to protect the public. So unless we create some kind of transparency, accountability, identifying what happens, then we risk law enforcement making those decisions about what the public should and shouldn't know, how they should go about, if you will, in some instances, intruding into the privacy of its citizens without any offset by a judicial determination of the appropriateness of that. So I'm wondering if those of you who are opposed to this could assist in, if I may, through the chair, how you would go about protecting. I realize you're very concerned, and I think rightly so, and I think the public appreciates when you can stop the kinds of attacks and dangers and violence that frequently does come with the ability to monitor and to surveil. But how do we as a public protect against the abuses unless you require that if you're going to do this kind of surveillance, you need a warrant first? Well, what's available to us other than a warrant, in order, other than the recommendations here, to try to maintain that very, very critical constitutionally mandated balance?
Through the chair, yes.
Madam Chair, thank you. Senator, I think that this bill, just as you said, or just as the chair said, this bill doesn't say what the policy has to say or what it doesn't have to say, which is correct. But this bill doesn't get into any question about the propriety of the use of any particular type of surveillance technology, whether a warrant is required or whether a warrant should be required, or it doesn't get into those sorts of questions. And so I think the answer is that the courts and the longstanding jurisprudence of surveillance and searches and what is appropriate and what is not is what protects against any potential inappropriate intrusions into privacy. I'm not sure that a public hearing or a piece of paper that says here's the type of surveillance we're going to use, and then the public's digestion of that information is going to necessarily protect or provide any privacy protections that aren't already in place through the existing system of a court challenge if a particular search is inappropriate or if a wiretap is unlawful. I mean, we have remedies for those sorts of situations, so I don't know that this addresses that particular question of privacy and propriety.
Well, if I may, we're talking about newer technologies. We don't need to wiretap anymore. We can just intercede a wireless communication that's going on. And unless we know what it is that law enforcement is doing as part of its surveillance. How can we determine whether or not it's appropriate?
Well, again, through the chair, if
Certainly, it seems somewhat philosophical, but,
if it's, I don't need to respond if it's.
well, if you have a factual answer, fine. Otherwise,
Well, I just think, again, laying that information out through a public policy is not going to be an arbiter, or it's not going to provide a venue to arbitrate or litigate whether or not some new technological advancement is to be violative of any privacy rights or concerns that are thought to exist.
Yes, if I may, this is, I don't actually, it is philosophical on one hand, but it's also a question of secrecy. Part of this is you have certain surveillance approaches you take, and you want to keep them, if you will, secret. So that becomes a problem, and that's what I'm asking you to try to address, because that's where I have a problem with your concerns about the bill. Come up with something that allows the public to have some knowledge and understanding of how you're going about doing what you're doing, to make sure that you're not going beyond the bounds of what is appropriate. Or is this going to be something that you think has to go to a court every time something happens? Does an attorney have to come in, a defense attorney come in and challenge everything you're doing automatically because the public otherwise has no idea? That's the question. Thank you, Madam Chair.
certainly. We'll hear from the other witnesses in opposition who are at the mic. Go ahead.
Madam Chair and members, Matthew Seiberling on behalf of the Association for Los Angeles Deputy Sheriffs and the Los Angeles Police Protective League, both in opposition. Thank you.
Lieutenant Shalisa Williams, San Bernardino Sheriffs, on behalf of Sheriff McMahon, in opposition.
Morning. Morning. Sean Rondo with the California Peace Officers Association, in opposition.
Morning. Joe Holler with the Security Industry Association, in opposition to this bill. Thank you.
And Brandon Up on behalf of the Los Angeles County Sheriff's Department in opposition. Thank you.
Ryan Sherman with the Riverside Sheriff's Association in opposition.
Randy Perry there and Reed and Associates on behalf of PORAC in opposition.
All right, so any other comments from the dais? Seeing none, Senator Hill, do you want to
Thank you, Madam
close?
Chair. And just to respond briefly, the opposition stated that this is a roadmap. And as we know, and that argument was not made when we had license plate reader legislation as well as cellular intercept technology legislation. And interestingly, Senator Jackson mentioned that about wiretaps in 2015, there were 1,148 wiretaps that led to the arrest of 976 people. And wiretaps are well known, but people still talk on the telephone and say the things. They know they're available, they know they're possible, and they know that it's something that could be used. So I don't believe that that is a roadmap for anyone just because the technology is available to a law enforcement agency. So this, and the idea that this legislation is too restrictive and it will shut it down is, I think, it doesn't really get to the heart of the problem. The heart of the problem is we have checks and balances. This legislation just requires that a local elected body make the decision of what type of technology that they're using, what policy is in place to the use of that, how long the information is kept, who has access to it, and what they do with it. This is not restrictive at all in terms of the ability to use the technology in the criminal, law enforcement capabilities that they use. So I respectfully ask for your aye vote, members, and as I said, this was very similar to the bill that we passed last year. Thank you.
All right, is there a motion?
Thank you, Senator.
All right, we have a motion before us. It's due pass to judiciary. Let's have a roll call.
Skinner?
Aye.
Skinner, aye. Bradford? Jackson? Aye. Jackson, aye. Mitchell? Mitchell, aye. Stone? Stone, no. Wiener?
We'll have the bill on call, and Senator Hill, I believe you have one more bill, SB 1355, and I found
Thank you, Madam Chair, members.
Before you begin, Senator Hill, it's an interesting